and then the witness went back to being emotional. And I've seen some pattern. Every time we speak, when we expect the witness to speak, the advocate comes in between us and the witness. Unlike the other advocates where they wait and ask you if they can come back after we had asked questions or made comments. So she comes in between. Because that comment made by Honorable Nomval, had the advocate kept quiet and allowed her to comment on what Honorable Nomval said, would have gotten somewhere. Instead, the advocate came in between without giving her the necessary opportunity. And we even proceeded to speak. Even when she was in a state, she was as if we were not interested in a condition. Because at the center of everything else, all of us here, at the end of the day, we must answer the question, was the witness fit and proper to appear before us? And fit and proper does not only mean the pains at the back. Was she in a right mental status to appear before us? Because from time to time, she breaks down. This is the second time. She's doing it again now. You see, and it's not something that you can blame it at her. She could be going through something that we are unable to detect. What is this thing? And we just said to her, now just talk. And then she says, you know, actually, when you made me to talk, I was under a heavy medication of antidepressant or something like that. But no one cared to ask me, am I fit and proper? Am I ready, emotionally stable to take this on? Because we this we are experiencing for the first time, Chairperson. But the last point I wanted to say was, I'm happy whatever way you continue with the witness, as long as there's nothing special that is being created for the witness.
One thing about Vusumuzi Matala and Sarah Jane Trent is that they do not cease to amaze us. Vusumuzi Matala has sent some correspondence at the Ad Hoc Committee telling them that they relied on chats which are fabricated. While Sarah Jane Trent, on the other hand, is seeking to have her testimony before the Ad Hoc Committee declared invalid, alleging that she was battling with post-traumatic stress disorder at the time she testified. I just hope that these two individuals have proof of these allegations that they've just raised. So what I'm going to do, guys, is that I'm going to attach the clips of the things that we discussed at the Ad Hoc Committee today regarding the correspondence that was received from both these individuals, Matala as well as Sarah Jane Trent. I hope you enjoy.
1, 2, 3 correspondences. Yeah. Thank you. You can start now.
Oh, okay, Chairperson. Chairperson, I'll start with the correspondence from Mr. Matala's lawyer. Chairperson, on the 19th of March 2026, we received correspondence from Mr. Vusumuzi Matala's legal representatives, Hlau Maluleke Attorneys Incorporated. In the said correspondence, a special power of attorney signed by Mr. Matala in Coxted is attached, dated the 13th of January 2026. Chairperson, at the heart of this correspondence is the allegation that the committee made use and relied on WhatsApp communications purportedly received from Mr. Matala's devices, and that the committee further made use of and relied on WhatsApp communication purportedly sent by or received from Mr. Matala's device by other witnesses on their devices. Chairperson, you will recall that Mr. Matala appeared before this committee on the 26th and 27th of November 2025, and his sworn statement is self-explanatory insofar as these text messages are concerned. In this regard, we draw the committee's attention to certain excerpts in his affidavit which deal with these text messages, particularly from paragraph 40 to paragraph 71. I'll start with paragraph 40, Chairperson. I'll just read 3 paragraphs, 40, 41, and 71. So at paragraph 41, and this is the affidavit which Mr. Matala deposed to the committee. I've been furnished with a bundle of WhatsApp communication between myself and Brown Mkhotsi by the evidence leaders, which I believe were taken from the statement of Lieutenant General Khumalo before the Madlanga Commission. The WhatsApp bundle is attached as VM4. At paragraph 41, the affidavit reads, I've been asked to comment in relation to these text messages and hereby provide my comments as follows. Now, Chairperson, at paragraph 71, he says, I wish the committee to take note that the comment is restricted to the messages I can recall. I submit the ones we can't comment to at this stage have either been manipulated and or altered, and I therefore cannot comment thereon. The point we're making, Chairperson, is that Mr. Matala commented and engaged with the text messages under review before this committee, voluntarily in the presence of his legal representative. Importantly, he did so willingly, independently, and without external coercion. Furthermore, you will recall that General Khumalo had appeared before the Madlanga Commission prior to making his appearance before this committee. Below, we provide an excerpt of General Khumalo's affidavit, which he presented before the Madlanga Commission. Paragraph 79 of the said affidavit reads as follows. I have been advised to take the commission through a series of WhatsApp chats extracted from the phones of Mr. Vusimuzi Matala, one of the leaders of the 5 organized crime syndicates forming the criminal cartel known as the Big Five. The consent form for the seizure and extraction of contents of the devices signed by Mr. Matala is annexed as SDK-10. The annex referred to by General Khumalo in his affidavit to the Madlanga Commission is an SAP-21 form, which is a consent to search computer and or electronic equipment with or without a search and seizure warrant. This document was signed by Mr. Matala on 14 May 2025. The point we're making, Chairperson, is that Mr. Matala's legal representatives have their facts crossed and they are backing up the wrong tree. Accordingly, this meeting should authorize us to write to them and set the record straight. So that's our recommendation, Chairperson. The third one, Chairperson, I'm looking for it now to be solicited. With a lot of things happening over my desk here. The third one, Chairperson, we received Chairperson correspondence from the attorneys of Ms. Sarah Jane Trent, dated the 23rd of March, 2026. Ms. Sarah Jane, you'll recall, Chairperson, that she appeared before yourselves on the 5th of March. And I think the purpose of a correspondence is to have her oral testimony, which was given on the 5th of March, declared invalid, struck from the record of oral evidence hearings, and for any transcription to be declared pro non scripto, as not written. And she says, the Chairperson, that she was diagnosed with post-traumatic stress disorder as early as 2017. And on the day in question, she was so overwhelmed such that she suffered a secondary trauma, which led to complete helplessness, on her part, in other words, re-traumatization. And that she has sought a forensic psychologist who she mandated to carry out an analysis of a condition and produce a report to that regard. She says, Chairperson, on the day she was unable to concentrate, to understand or follow the questions, and was unable to answer questions in a cogent manner. She even makes allegations, Chairperson, that she was held against her will. Chairperson, our recommendation here is that, look, we we are worried about the fact that Chairperson, remember let's talk about the personality involved here first. This is an admitted attorney, Chairperson of the High Court, so we're not talking about, yes, she's on the non-practicing role because she's not practicing. We're not talking about just any person from the street. There were consultations, Chairperson, which took place between her and our evidence leaders, not once, not twice, on numerous occasions. And she had an attorney, assisting her, Mr. Terrell Fuman. And even the affidavit which she put together, which is now part of the record of the committee proceedings, is work which is a product of her consulting with the attorney, which is Mr. Fuman, and also consulting with evidence leaders. The difficulty with this, Chairperson, is that we're apprehensive about it because our view is that if we start getting an avalanche of letters like this, people saying, yeah, look, the evidence I presented to you because of 1, 2, 3, 4, 5, it must be excised and so on, we will end up not having a report in front of us. And we think that even though, Chair, this is quite a difficult one, but we think that, Chairperson, the only competent forum which can excise or which can force us to excise evidence is a competent court of law. And Chairperson, that's our recommendation. That, in fact, even the report from the forensic psychologist, we have not even received it 8 days after she wrote to us. But our recommendation, Chairperson, is that we should be very much circumspect of people appearing before us and then writing to the committee and saying that the evidence should be excised. But look, we're not on a good. She is not on a good wicket, Chair, because, as I say, even the report that she makes reference to, that she's still seeking, is not objectively and factually before the committee. I'll end with that, Chairperson. Thanks very much.
Before I can play the reaction of the members of parliament, which led to some disagreement happening between Honourable Souls and Honourable James, and them having some kind of Honourable James even lashing out at Honourable Souls, I just want to point it out that we all saw what happened at the Ad Hoc Committee. Miss Sarah Jane Trent was told many a times that she should be strong. She's not fine. They took as many breaks as needed.
Sure. Okay, yeah, I must see you. Good morning, Ms. Trent.
Good morning.
How are you?
I am okay.
You okay? You were crying profusely earlier on.
Yeah, it's this.
Why were you crying?
It's this PTSD kind of. I was completely fine, and then it all comes rushing back.
Oh.
And it's very overwhelming and embarrassing as well.
It is embarrassing.
It is,
especially all the things you've done.
The members of parliament now and again assured her that this is a safe space. No one forced her.
I think that it would be quite overwhelming for any person, including myself, to have to make a speech off the cuff. And my suggestion is that we continue with the statement of the witness. The witness did rely on that provision, but she may have been mistaken to rely on that provision. But we can proceed to talk into the matters as to why we are here, which speak into the terms of reference. And she will answer the questions that honorable members have as we go along. But I think that it may be helpful to, maybe even for me to deviate from the planned questions and just for the witness to speak into her statement. She can read it in.
What do you suggest, Advocate?
To use the statement as a guide for the witness, and she can read her paragraph into the statement, into the record, and we can then field questions that way. Yeah.
Before I take the honorable members, let's hear what does she want us to do. Miss Sarah Jane Trent.
I'm happy to go through the statement.
Okay.
If she felt like she was not mentally stable, she could have voiced it out there and then that I'm not mentally stable and I'm not sure about what I'm going to say right here. That's the thing, guys. We are not talking about just anyone. We are talking about a legal practitioner. So I just think that to a certain degree, this is some kind of like an attack on Honorable James, because Honorable James like did give her a hard one. Not just her, even McBride gave them a hard one. So I just think that this is some kind of payback, because they just want her to scrap the testimony, because they're realized afterwards that she messed up a lot of things, and she painted Mr. Paul O'Sullivan in a very bad light.
With regards to the representations of Mr. Matala, they're at the wrong place. We can't help them with the authenticity or otherwise of the recordings, and he should approach the people who presented them. There's nothing we can do about it. I was not there the day Ms. Trent gave evidence, but generally I agree with the proposals of the inputs of Honourable Sangani. We can't now be striking evidence off the record. In any event, I don't believe that the committee has the power to do that. So, if they want that end result, then the only option would be to take us on review. I don't believe there's any other way around that, Chair. And what was the third issue? I forget now.
Is which is SAPS. With regards to the second correspondence, where Sarah actually is now trying to say that what she presented there actually was done under some kind of duress. I think that is devoid of any truth, because we were all there, and not once, in fact, it was a number of times where some honorable members were suggesting that perhaps she was not in a good mood to continue giving evidence, and she insisted. And there were pauses where she was allowed to go out and recollect himself, and she came back and continued. So it cannot be that now she wants to actually then withdraw such evidence which she actually freely gave herself. The third point is yes, we concur with the suggestions, and that we actually as a committee go and have a look at that document, classified document, which the minister is prepared to make available to the committee to go through. The sooner we have the date, the better, so that we can actually organize our activities so that we are able to have sight of that document. Thank you, Honorable Chairperson.
Honorable Chair, thank you. In terms of the first one, Mr. Matala, I agree that we are not responsible for providing those details, because it was presented to us as evidence in the different affidavits from the witnesses. And it is from that basis that we interrogated that particular information. So I suppose the records of the different sittings for that need should suffice. And if they want to go in depth, they have to speak to the officials that provided that to us. On the issue of Ms. Trent, the committee can only take responsibility for what happened within our sittings. And for what happened in our sittings, which is publicly available, we were fair. It can be shown that she was not forced or coerced in her testimony. So that is there, it's available. So the committee is clear that we have not coerced her. Where the committee cannot comment as a formal structure is what happened outside of the committee sittings. In her affidavit, when she speaks about her experience in the toilet with Honorable James, claiming that Honorable James has manipulated her, calling her a strong woman there, and when she came back into the sittings, she was told by Honorable James she will crawl out of there, and she was humiliated. Now we
Chair,
can
may I
say,
come in here, please? Point of order, because Honorable Sauls is clearly out to disrupt today, and I'm not going to have it. I'm not Honorable Skosana, because you weren't in that bathroom, so you can't just come here and make allegations. You clearly have a lot on your plate, coming here to disrupt this entire meeting and trying to aggravate us.
may I continue, Honorable Chair?
He's completely out of order today.
Would you please allow the honorable member to speak, and when he's done, you can request an opportunity to say what you want to say. May you continue, Honorable Sauls.
Thank you, Honorable Chair. I'm not making the allegations. Ms. Trent is making the allegation, and we are asked to comment on the allegations that Ms. Trent is making. So it's not me that's talking about Honorable James. So my thinking around what Ms. Trent is saying is that we can't answer for what happened in the toilet. It is only Honorable James that can answer whether or not what Ms. Trent is saying happened in the toilet is true. That she was manipulated so that she can come back to be humiliated on TV by Honorable James. We don't know whether that's true or not. It's only Honorable James that can tell us that, and Ms. Trent. So, to protect the integrity of the committee, I'm saying the committee is not guilty of coercion. The public record is there. As to humiliation by Honorable James in the toilet, we can't talk on that because we weren't there. Only Honorable James can say what has happened there. Then on the third one, I do agree that we should have sight of that report, Chairperson. I thank you very much, Chair.
Honorable Vestal.
Thank you, Chairperson. I agree with all three recommendations. Nothing to add. Thank you.
Thank you, Chair. Let me not breathe down anyone's neck. Chair, on the first matter, that is definitely a SAP's competency when it comes to the chain of evidence. On the second one, on the availability of the report, I don't think that I should give any input on that. The third matter, I want to say that Ms. Trent was given several opportunities to opt out, and she insisted that she was fine. Also, we must note that Ms. Trent changed her statement last minute, I think the day before, because I think she was actually being put under pressure by Mr. Paul O'Sullivan. She kept receiving calls by Mr. Paul O'Sullivan, and we do know and we recognize that she was under duress and she was traumatized. But at the end of the day, she was given the option, to excuse herself. We also cannot be striking anything off the record. She has made a bed and she needs to lie on it. As for Honorable Sauls, he's not worth my time. Thank you.
Chairperson.
You hear me now? Honorable James, are you done?
My time. David, what transpired there? We weren't there. We need to know from her so that the committee knows. Is it true that she convinced her to come to humiliate her as she alleges in her affidavit? So it's not about my time. I don't need time from Honorable James.
Honorable James, you need to respond to the statement.
Chair, I want to put on record, I was speaking to Ms. Trent. She was nervous. She told me she's nervous. She came to me because she said she's actually so nervous of me. She's afraid, she's scared. And I told her to calm down, she'll be okay. That was what the conversation was all about. And that's it. Thank you, Chair.
Honorable Skosana.
I'm not sure whether you will hear me now, Chair. Am I audible?
Yes, Honorable Member, we can hear you.
A quick one, Chair. The first one, I think the issue of the lawyers, like Honorable Sangwedi said, I think if I remember well, is that if we have to entertain that, Chair, I can tell you we won't move.